Hello and welcome. This is Grant Hughes of Grant Hughes Investigates on YouTube. This channel evaluates all aspects of true crime. As you are aware, videos and live streams in this genre often discuss elements of crime that may be disturbing to some viewers. If necessary, take the precautions needed to avoid these feelings. Factual information related to cases is the key to fostering rational true crime discussions. Fortunately, you will find that here. Please hit the like button only once, share the video, and subscribe if you like my content. Thank you very much for watching.
Correct.
We are all Richard Allen!
Huh? It's a house!
5 brain cells, 4 aren't working. There's mosquitoes the size of bald eagles in that dadgum swamp.
Damn thing doesn't kick in. Crazy. Alright, well, we have lots of hours of live streaming today, and not even at half of the goal, if you can believe that. Combining the shows. pretty sad. But what we're going to do here is we're going to play the so I've got like this audio, and this is the PDF file from the defense team who is putting out a response to Macleod's latest response, showing that in fact it mentioned that Richard Allen was at the crime scene. You know, it's all bullshit, just to be honest with you. None of it's reality. But he's now arguing. I think there's something wrong with Baldwin mentally. Like, I think he's mentally ill of some sort. Very strange person. You know, fighting for stuff that just doesn't even make any sense. Hey, look at that. K-Me gifted 5. Will GSU PM get one? I think you need to re-sign up on that. I think you need to, like, make yourself not available and then available again. We got Taylor, Jack Green. These people aren't even watching right now. Jane Tonks, Bogart, and KB Investigates. Alright. Need about 15 more of those and we'll be, yeah, kind of at a, not sure, I mean like 20. He's done that 5 times. Oh, you have? Really? Jeez. Okay. Well, how about now just leave yourself there and we'll see what happens. Are you a member of my channel? Like, did you subscribe, or you just sort of show up all, you know? Maybe that has something to do with it. Because sometimes, like, you just get notified and you watch a channel over and over and over again, then you realize, wait a minute, I'm not even subscribed here. Just a thought, you know, just a thought. I guess that would make it so that you wouldn't get one on that channel, I would think. Okay, well, I figured you did, but that was just some kind of a thought. Yeah, half of them you've never seen before. But like I was saying on the earlier stream, I think Baldwin and Rosie sold Richard Allen a bill of goods and his wife, Kathy, because Richard Allen confessed many times with a rational mind, calmly and, you know, rationally told his wife that he did it. He just wanted to make sure that they knew that he did it, and wanted to make sure that they loved him, even if they did it, you know, even if they knew he did it. And so but Baldwin and Rosie were so excited to have this really big case and thought that they could, you know, trick the public using the Odinist stuff and all that garbage to try to sell a bill of goods to a jury to get them to acquit Richard Allen. But none of those things were allowed. So when they went to trial, they had nothing. They got to trial and they didn't know what they were doing. I thought it was one of the worst defenses I've ever heard of. I mean, it's just like they had nothing, and they think that's because the judge didn't let. No, the judge didn't let you use the shit that you wanted to because you guys could create no nexus. You found there was nothing. You proved nothing in that 3-day hearing that showed that there was a connection between the people that you wanted to talk about and the crime scene. Nothing. And you lost, so now you're scrambling to try to help out in some way, and it's just coming across as just almost childish. And that's the reality right there. Now you're going to listen to you hear them, and all the attorneys out there will explain, oh wow, what this guy is really, oh, he's really working his ass off, he's doing this and that, and it's just garbage. Okay, but while we're doing this show, if you have the ability to help support the channel, that'd be great. If not, then not. Okay. All right, so here we go. We're gonna do. I'm gonna see how this works because it's weird. Watch how weird this is. This is using Chrome, but if you go a little too wide, you can't see the PDF file. But if you're right there, you can see it. So I'm wondering if it actually follows it down the screen. That'd be pretty awesome. Let's see. Let's turn that off.
Filed March 4th, 2025. Carroll Circuit Court, Carroll County, Indiana.
Oh, it is.
State of Indiana,
Okay.
SS.
Huh,
County
look
of
at that.
Carroll, State of Indiana.
That's awesome.
V. Richard Allen. In the Carroll Circuit Court 1, cause number 0801 to 2210 Memazor 000001. Richard Allen's
Hey, thanks,
verified
Joe
reply
Walker.
memorandum to State of Indiana's response to preserve.
I have a Richard Allen prison mail info. Should I share it so we can tell him to confess and apologize? Yeah, if you want to email it to me, maybe I would send him an email. Is it like you have to send a letter to him, or can you send an email? That'd be pretty interesting.
Preserve and produce and request for sanctions.
Wow, thanks so much, GSUPL. Hey, thank you. Appreciate it. Very cool, very cool. All right, here we go. And we got to see the cat finally. Usually I have that thing turned off. I haven't seen that in a long time, the full thing. Anyways, thank you so much. Appreciate it. And sorry you had to see some of the crazy communities online that hate my channel so much because they don't like my personality.
Comes now Richard Allen by counsel and files this reply to the State of Indiana's February 28, 2025. Response to Allen's motion to preserve and produce, and also request sanctions for the state's violation of Carroll County local rules concerning exculpatory evidence. In support of said motion, Allen states the following. The prosecution's response brief provided proof that the state of Indiana failed to turn exculpatory evidence over to the defense. In his response, the prosecutor glosses over the fact that he was in possession of letters that he failed to turn over to the defense before trial, even though in a February 13, 2025, email he denied possessing such letters.
Yeah, so those are the, remember he said he found 2 of the 3 letters? So he found 2 of the 3 letters, and they all mentioned Richard Allen, which is opposite of what Andrew Baldwin claimed.
Macleod also has no explanation as to why a letter from Davis from October 15, 2024 is missing and cannot be found. Instead, the prosecution spends the majority of his response denigrating defense counsel.
As
Prosecutor Macleod is not the arbiter of exculpatory evidence or whether he has an obligation to turn it over. The law is the arbiter. Exculpatory evidence is defined as evidence tending to establish a criminal defendant's innocence. State Vuodoret, 93
Not sure why it changed language there, but does it really matter, Truth Seeker? Who has the dog, Murphy? It doesn't really matter at all. Has no bearing or relevance of any kind.
Carroll County Local Rule 18b2 also requires Macleod to turn over exculpatory evidence. Based upon his February 28, 2025 filing, we now know that the state of Indiana had certain letters in its possession in October 2024, but failed to turn those letters over to the defense until February 28, 2025. The prosecution only produced those letters after the defense sought those letters, being forced to file a motion to produce those letters after the prosecution failed to admit being in possession of those letters. This behavior of the state is consistent with a pattern of behavior that has greatly impacted the defense and Richard Allen's constitutional rights throughout the entirety of this case, as will be recounted later in this memorandum. A pattern of withholding exculpatory evidence may lead to a reversal and new trial. Prelude vs. State, 819 NE2D 393 Ein das CT.P. 2004. This case in a withholding exculpatory and material evidence from a defendant prior to trial. In Prelude, the Court of Appeals reversed the conviction when soon after the conviction, the defense counsel learned of evidence that the prosecutor failed to turn over to the defense prior to trial. Defense theory. At Allen's trial, the defense indicated that the evidence supported that on February 13, 2017, the victims were abducted, taken somewhere else perhaps in a vehicle. And then during the early morning hours of February 14, 2017, after the search parties had left the area, were ultimately transported to the location where they were found on February 14, 2017. Further, the defense...
Yeah, I mean, I told you that some of those elements match the story that Baldwin and them came up with, but I think they came up with the story by reading these letters before, or hearing the same story. That's what I think.
His theory was that evidence strongly supported that multiple people were involved in the abduction and murder of the victims. The defense theories were detailed in the defense's opening statement and throughout trial or in offers to prove from August 1, 2024. State's theory. The state's theory was that in some order the following events occurred: the killer, acting alone, after running or briskly walking.
Oh, yeah. Here's Andrew Baldwin acting like a dipshit again. Okay, I don't mean to be, but I can't stand the guy. I think he is a scumbucket slimeball. So this whole paragraph right here, guess what it sounds just like? It sounds exactly like the Odin document. One single solitary man acting alone with dexterity, that whole crap. So now we know that Baldwin's the idiot that wrote that portion. Although, if you listen to Mata, it was the greatest document ever written. My God, it was just trash.
The state's theory was that in some order the following events occurred: the killer, acting alone, after running or briskly walking across a bridge to catch up to the girls, since he was not seen in the 207 photograph anywhere on the bridge, was seen on video, walking casually and not panting like a 45-year-old man who had run across the bridge, then abducted the two victims, walked, slid down a steep hill with those victims. Then, in a panic after observing a van, corralled those victims across an active creek while holding a gun, and then both victims somehow were undressed.
An active creek? What?
But the younger victim was later redressed in the pants.
No, they weren't redressed in the pants. She dressed herself, you idiot. We've gone over it 1,000 times. She was allowed to redress herself, and you'd know that, Baldwin, if you just looked at the crime scene photo that you've seen. Her hands are curled up inside the sweatshirt. That means she was still alive when it was put on. Okay, Baldwin? But I know you want to keep repeating it over and over and over that somebody else dressed her, and you've been proven to be incorrect and not accurate.
And sweatshirt of the older victim, and the lone panicked killer murdered one victim and then murdered the other victim without anyone hearing any screams in spite of sound traveling very well throughout that area.
Right, but what if they didn't scream? Not all people scream. I think that's just from the movies. Everybody thinks that.
The way to the bridge, then the lone panicked killer moved the older victim from one area to another area next to...
See that, the old panicked... You see how he's writing this shit, you guys? That says, then the lone panicked killer moved the older victim from one area to another. So now we know that he's the one that wrote the one single solitary man garbage.
To a tree without any drag marks, indicating that he carried her from one place to another. All that activity, according to the state's theory, occurred in a 19-minute time frame between 2:13 p.m. and 2:32 p.m., when the older victim's phone stopped moving, having been placed under a shoe under the younger victim's body. After the murders, the state's theory was that this panicked killer then took time to place sticks on top of the victims' bodies in particular patterns as depicted in photos admitted at trial, and then, in spite of his panic, hung around the crime scene for over an hour before exiting the crime scene northward near a cemetery, before this panicked killer chose to walk westbound toward his vehicle on 300N, in a bloody outfit, knowing that he would be in full view of any vehicles traveling that road, after having killed the victims an hour and a half earlier. The state's theory was not that multiple men-women were involved in the crimes, but one man alone committed all these acts and did so on the afternoon of February 13th, 2017.
Right, but your little buddy Ricci actually said that Richard Allen was involved. So are you going to include that in there?
Ricci Davis letters provide exculpatory information that supports the defense theory and negates the state's theory.
No, it doesn't. No, it doesn't. It doesn't negate the state's theory at all. Doesn't negate them at all. Their theory worked with the information that was proven at trial, and it actually doesn't work for your theory because you said Richard Allen wasn't there. Ricci Davis says he was there. So if you want to include him in your theory now, then yeah, that sounds great.
Also provides other information that the defense could have utilized for trial or to support its request for third-party suspect evidence to be admitted into evidence. In Davis's letters that the state of Indiana did not turn over to the defense before or during trial, Ricci Davis stated that Keegan Klein, a key suspect in the case, confessed to the murders. A key suspect confessing to the murders is exculpatory evidence as it tends to establish a criminal defendant's innocence. ID. At a minimum, Carroll County local rule required McLeland to immediately turn those letters over to the defense. Even if McLeland believed that the letters did not need to be turned over because of Davis's claim that Richard Allen was involved in the crimes alongside Klein and Logan. When police or prosecutors conceal significant exculpatory or impeaching material in the state's possession, it is 1 Carroll County Local Rule 18b. 2. Additionally, McLeland's claim that he was ordinarily incumbent on the state to set the record straight. So, the question is not whether the defendant would more likely than not have received a different verdict with the evidence, but rather in its absence he received a fair trial understood as a verdict worthy of confidence. File 4 days, a very lengthy 434. U.S. Supreme Court 1995. The jury in Richard Allen's case was out for nearly 4 days, a very lengthy deliberation period. In this case, Keegan Klein's confession to the murders, and also Klein's claim that Ron Logan was involved, are clearly exculpatory statements. These were the two most likely suspects.
Right, I know, but here's the thing. He says that, but then he also says that Richard Allen was there. So it's weird how you want to cherry pick those two people being involved, but not your client. Because if you read that, because Ricci's letters said that Richard Allen was involved. So that absolutely implicates your guy, even though we all know that the facts said in Ricci's letters are completely bogus. So none of it's exculpatory. It's all made-up information.
During the investigation.
And all he did was, listen to some comments people were making and put together a theory. That's it.
If it could be shown that they knew each other, that would be a significant fact for the court to consider when determining matters of the third-party suspect defense and also for a jury to consider. The fact that Klein also implicated Allen would not have been of a concern of the defense, as the defense knows that Allen had no linkage to either Klein or Logan, and also because the evidence supported that Allen was with his wife the night of February 13th and the morning of February 14th.
Right. I mean, okay, so you're saying, right, he went home after he killed them. So he was there the night of the 13th. See, this guy is a lunatic, you guys. The evidence supports that he was home on the night of February 13th. And still at home on the 14th in the morning. Right. Exactly. Okay, he went home after the killing. When he was seen, it was 3:50 something. Or 3:57 or whatever. Muddy and bloody, if you want to believe that part. So that means he's going to be home that evening, and then he gets back in the morning. So your evidence doesn't show anything. Yeah, it's just this guy.
When Klein is claiming Allen was with Logan and Klein committing the crimes. Had the defense known of the information contained in the Ricci Davis letters, it would have renewed its motion for third-party suspect defense regarding Klein and Logan, and would have further investigated these claims. Perhaps the defense would have sought a continuance to investigate the ties between Logan and Klein. The defense could have argued that Keegan Klein knew details of the crime that no one else knew, and furthermore that Klein was protecting an unknown third party by claiming that Allen was the third party after Allen's arrest.
Okay.
The defense.
So now they're saying he's protecting somebody else by claiming it was Richard Allen. But you said that he never said it was Richard Allen in your original statements, Andrew Baldwin. In your first motions, you said that he never mentioned Richard Allen, but now he does, so now you're going to come up with another reason why he said it. Oh, he's saying it now because, come on. All right, guys, I think we're $40 short of reaching the goal. So if you guys have the ability to do that in various forms related to the channel memberships or super chats, that'd be great. So look at that.
Defense could do none of that, as well as any other number of legal, strategic, procedural maneuvering if the defense was in the dark about the contents in the letters while the prosecution was fully aware of that information. The details that Klein provided to Davis add to the exculpatory value of those letters. On page 4 of one of the letters, Davis claims that Klein detailed that the girls' bodies were moved 3 times and that they were not killed where they were found, and furthermore that their bodies were staged. These are facts consistent with the defense theory and facts that oppose the state's theory.
Right. But see those letters, you know when those letters were written? The ones that he's referring to right now? They were written in October of 2024. Guess what? All of that information right there, guess where that originated from? That came from the Ron Logan search warrant. All of that was in there, that the girls' bodies were moved. So he had heard about that already. He wrote these just right before trial started, these letters. So that's what I mean. This Baldwin guy is completely disingenuous. Okay? So by the time this guy wrote those things, the Odin document had already been put out there. Ron Logan's document was out there. And, I mean, you guys get what I'm saying? I hope you do, because it's just absolutely garbage. Ron Logan's document mentioned that the girls' bodies were moved. Okay? Then you came out with the Odinist document too, so he would have access to knowing about all of those things before crafting some sort of a, comments. That's why there's some overlaps, information that sounds exactly the same. I mean, don't you think it's pretty interesting that he used the exact same phrasing almost, like they were not killed where they were found and their bodies were staged? That's what they used in the Ron Logan document.
Theory. Furthermore, in the letter, Davis claims that Keegan Klein detailed how the killers got nervous and left town in their own cars, with at least one of them going to Lafayette to get rid of evidence. It is known that Ron Logan went to Lafayette at some point in time to purchase exotic fish, after having asked a relative to assist him, Ron Logan, in creating an alibi.
Guess what?
These are all facts that Richie Davis would not know.
And guess what? I just mentioned the Ron Logan document. He would know that. See, this guy's a liar. He would know that. Because these all came out in the October 2024 letters, and all somebody had to do was give him access to or read the information that was in the Ron Logan search warrant.
But that the killer would know.
Bullshit.
All of those facts tend to establish Richard Allen's innocence. ID. In the second letter, Davis claims that back in 2018, Davis reported that the victims' throats were sliced. This is something that only the killer would know, especially when the details of the murders were not known at that time. He also stated that he reported that the girls were hidden in a barn and also driven around at some point in time. This is consistent with the defense theory that the girls were driven in a car at some point and held somewhere until the search parties had left the area, and inconsistent with the prosecution theory. On page 3 of that letter, Ricci recorded that Keegan Klein told him that the scene was staged and, furthermore, mentioned that the girls could not be moved because the search parties were everywhere throughout the night at that time, meaning that the girls were moved to the place they were found only after the search party left the area. This is just as the defense claimed, thereby supporting the defense theory and negating the state's theory.
Ridiculous.
In his February 12, 2025, interview at Newcastle Prison, Richie Davis provided further details that Davis claimed believed that he also provided to the prosecution concerning details that Keegan Klein stated to Davis. In that interview, for example, Richie Davis claimed that Keegan Klein stated that the girls were handcuffed to each other. After the meeting, defense counsel Augur Baldwin and investigator Matt Hoffman viewed the crime scene and autopsy photos to determine whether there were any indicators on the victims' wrists that would support this new information that the victims were handcuffed to one another. The admittedly non-expert eyeballs of the attorneys and investigator observed straight lines on the left hand of the wrists of both girls, which, if true, could indicate that one victim walked immediately behind the other with each of their left hands handcuffed to each other so that they could not easily run away. If the defense had received these letters, it could have learned these facts from Davis during a deposition if they weren't contained in the letters, and then had experts view the same photos to determine whether the photos were indicative of the girls being handcuffed. Had the defense known of the Keegan Klein statements to Richie Davis, it could have brought both Keegan Klein and Richie Davis in for a deposition after hours or during the weekend while the trial was occurring. These depositions could have revealed additional information, including whether at some point in time Keegan Klein finally admitted that Richard Allen had nothing to do with the crimes, as Richie Davis stated to counsel during a jail interview on February 12, 2025. And also to show that Keegan Klein's claim about the activities of the third person involved with him, Klein, and Logan was inconsistent with Richard Allen's whereabouts the night of February 13 and morning of February 14. The defense, likely, would have called upon Kathy Allen to show that Richard Allen was at home during that time frame, and not with Logan and Keegan Klein. Additionally, the defense could have asked the Department of Corrections to provide video from the very pod where Richie Davis and Keegan Klein were housed to determine whether Klein and Davis were frequently talking with another, as Klein has apparently stated in State's Exhibit 4 that Klein has only talked to Davis, maybe 2 times. If the video shows that Davis and Klein talked to each other well beyond 2 times, then it could be determined that Klein was lying. Whereas, if the video shows that Davis only talked to Klein 2 times, then it would show that Davis was lying.
What if it was 3
Either
times?
way, the defense had a right to those letters to conduct its own investigation concerning the veracity of the contents of those letters. McClelland's claim that he did not turn over the Davis letters because he, McClelland, made his own determination that the letters were not in fact exculpatory denied Allen and his attorneys the opportunity to conduct its own investigation from the information contained in those letters and to determine what to do, if anything, concerning the contents of those letters. In his February 28, 2025 response, McClelland makes much noise about Attorney Baldwin attempting to put into the public domain information through the filing before verifying that information. It should be noted that Attorney Baldwin first attempted to work the matter out with McClelland via email before filing his motion. On February 12, 2025, Baldwin had emailed McClelland asking for the Richie Davis letters. On February 13, 2025, at 2:41 p.m., McClelland responded as follows. The information that we have concerning Richie Davis was forwarded to you as part of discovery. You had every opportunity to call Mr. Davis at trial or at the hearing on third-party motive. You chose not to. Your strategy was not to call those people. The trial is now over. Richard Allen was convicted. If you feel you need to file additional motions, then file them. The state will respond appropriately. The state will follow any orders the court puts out in regards to those motions. Emphasis added. Before filing any motions, Attorney Baldwin made one more attempt to simply obtain the letters. The defense responded at 3:54 p.m. on February 13, 2025, by asking McClelland whether he was admitting or denying that he, McClelland, had received letters from Richie Davis in the months leading up to the 2024 trial. McClelland could have quickly answered the question and then provided the letters to the defense, and perhaps avoided any more filings. McClelland also could have asked Baldwin to hold off on filing anything while he, McClelland, gathered the letters to turn them over to the defense. Instead, McClelland chose to ignore the defense's request, prompting the defense to file its February 14, 2025, motion to preserve and produce the Richie Davis letter. It should be noted that the defense was seemingly up against a deadline of sorts. If the defense waited to file their motion, the judge might rule on the motion to correct errors beforehand, which arguably would prevent the defense the ability to file the motion to preserve and produce, as such a ruling would arguably kick the case to the appellate lawyers. Also, note that in his February 13 email response, McClelland claimed to have provided the defense all the Richie Davis letters during discovery. This was simply an untrue and misleading statement typed on his computer and sent to the defense by McClelland. Through his February 28, 2025 filing, this court learned that McClelland actually was in possession of these letters on February 13, 2025, which contradicted McClelland's representation to the defense that everything had been turned over. McClelland chose to intentionally mislead defense counsel about his, McClelland's, possession of those letters. McClelland was getting called out by the defense once again too, and once again he was ultimately forced to turn over the letters, perhaps out of fear that the defense would eventually gather doc records that would then expose McClelland's misrepresentation. McClelland's misrepresentation has yet to be explained by McClelland to this court or anyone else. Are the letters McClelland finally provided to the defense truly the only letters and or videos in his possession?
Okay, but if there's other letters and they say other things, then that means he's just... See, what Richie was doing was going around just exactly what Keegan Klein said, that he would go around and try to get hold of different prosecutors out there and theorize on different cases and try to get some sort of deal cut. You know, that's what his goal was. But hey, guys, if you're out there, if you can help support the channel, that'd be great. We're still short of the goal today. I've been working hard. This is the 3rd show that I've done, hoping to try to get there. So if you have the ability to, that would be great. Thank you. Started off pretty good on this one, and then it just went to 0.
McClelland's recent response to the defense motion to correct error provides troubling statements that cast doubt on McClelland's claim that these are the only letters or evidence that are in the prosecutor's possession. In the prosecution's response to the defense's motion to correct errors, in an apparent attempt to discredit Richie Davis, McClelland claims that McClelland had information that Richie Davis had claimed that Ron Logan took batteries out of Libby's phone. This is curious because the prosecution has failed to produce any document or videotape in which Richie Davis makes such a claim. The defense has found nothing. This leads to serious questions of where did McClelland learn of this information? The defense is left with one of 2 possibilities. 1. McClelland has additional Richie Davis letters, reports, or video from where McClelland gained that information. Or 2. For reasons that are unknown, McClelland made up the story. It seems unlikely that such a specific story would be made up, leaving the defense to conclude that McClelland has additional Richie Davis letters, reports, or video, but has not turned it over to the defense. McClelland has not explained to this court, nor anyone else, from where McClelland claims he learned this information about the batteries. Nor did McClelland back up his story about the batteries with an exhibit attached to the filing. Also, note in that email that McClelland requested attorney Baldwin to file something, which Baldwin did, only to have McClelland then cast aspersions about the filing. McClelland's history of holding on to exculpatory evidence until being forced to, or called out, by the defense. Unfortunately, as has been the historical pattern of the prosecution, McClelland made the decision to hold on to those letters until called out by the defense, much like he made the decision to hold on to other exculpatory evidence over the course of this case. Again, Indiana courts of appeal have commented on patterns of withholding exculpatory evidence and have even reversed convictions when prosecutors have exhibited such patterns. Prelude at 397. Steve Mullins claimed that the Brad Holder and Patrick Westphal and other crucial early interviews between February 14, 2017 and February 20, 2017 were recorded over, was not relayed to the defense until January 30, 2024, in spite of the defense asking for that evidence since August 10, 2023. As anyone in the criminal justice system knows, often the most important interviews are those interviews closest in time to the crime. Brad Holder and Patrick Westphal were on law enforcement's radar screen as suspects very early on in the case, a fact that is evident from reviewing emails all the way up the chain to Doug Carter in the early days of the investigation. Those emails were admitted as evidence during the July 30 to August 1, 2024 hearings. Because of law enforcement's very early interest in Brad Holder and Patrick Westphal, each were quickly found and then quickly interviewed on February 17, 2017, within 3 days of the murders. On August 10, 2023, the defense first unveiled to the prosecution that defense believed that the state's own evidence supported that Holder and Westphal were involved in the murders. From a single 2-page document found among hundreds of thousands of documents, the defense found evidence that law enforcement had interviewed Holder and Westphal on February 17, 2017, and that both interviews were memorialized through audio videotape. It was after the August 10, 2023, deposition of Jerry Holman that the defense began demanding those interviews, which the prosecution should have already provided to the defense. When McClelland and Mullen failed to turn over those interviews, or explain what had happened to those interviews, the defense called out the prosecution in the Franks memo filed on September 18, 2023. Footnote 66 on page 56 of the memorandum details that the prosecution had failed to turn over the Holder and Westphal interviews that the defense had been seeking. Even after the Franks memo was filed and the defense alerted the court, calling out the prosecution for not turning over the Holder and Westphal interviews, the prosecution still refused to answer the very simple questions posed by the defense of where is the Holder and Westphal videos? Please, turn them over. The defense heard crickets. Instead of immediately alerting the defense on August 10, 2023, that those videos had been taped over, McClelland and Mullen said nothing. Finally, on January 30, 2024, the prosecution provided a document that detailed some of the contents on certain hard drives that it had turned over to the defense. In the fine print, on page 5 of this document, the defense finally learned what McClelland and Mullen were claiming happened to those crucial interviews. They were recorded over, along with all other crucial interviews between February 14, 2017 and February 20, 2017. Neither McClelland nor Mullen called the defense and said, "We should have told you this when you first got on the case, or at least back in August 2023, but those interviews you have been seeking for the last 5 months were taped over in 2017. Defense counsel has practiced for over 30 years. During that time, if the prosecution in any other county ever received exculpatory evidence or learned that certain evidence had been destroyed, it would immediately contact the defense and tell them on the phone or in person that the evidence had been destroyed. In this case, the defense was lucky to even notice Mullen and McClelland's claim that the crucial video was taped over, as such information was sandwiched between other minutiae contained in a document. This should also not be overlooked. If in fact those crucial videotaped interviews were actually taped over, that would be colossal news that Mullen and McClelland would not have forgotten. Losing such evidence would be the talk of the unified command due to the serious nature and potential serious consequences of losing such important evidence. To lose such crucial evidence early on in the case would not be the type of thing that would ever leave the memory of the man in charge of that evidence, Steve Mullen, nor the minds of those in unified command. Therefore, when the defense requested the prosecution to turn over those interviews, Mullen and McClelland should have immediately said to themselves, "Oh no, those interviews were erased back in 2017. I need to immediately tell the defense." I should have told them that when they got on the case, but I will do it now. It is inexplicable that Mullen and McClelland would not have remembered in August 2023, when the defense first requested those interviews, that those interviews had purportedly been recorded over. Yet, neither McClelland nor Mullen told the defense of this earth-shattering type of news that Mullen had known for 6 years at that time. To make matters worse for Mullen and McClelland, when the defense finally learned of the so-called recorded-over interviews, the defense asked if there was some documentation memorializing what exactly happened to those interviews, how it had happened that crucial evidence had been recorded over. Surely a report existed that would explain this terrible accident that caused crucial evidence to be forever lost. However, no such report had yet been tendered to the defense. Some point in time later, the defense finally received such a report. It was drafted by Steve Mullen. Inexplicably, it was undated. Therefore, no one knows if the report was drafted in 2017, or sometime in 2024, or anywhere in between. That document was entered as an exhibit at the March 18, 2024, motion to dismiss. This undated document is not normal, nor the normal way that law enforcement and prosecution operate. The question must be asked, therefore, why did Mullen and McClelland not immediately alert the defense that the Holder and Westfall and many other interviews were recorded over when the defense first asked McClelland and Mullen for those interviews in August 2023? And why did Mullen and McClelland not turn over the undated document purportedly explaining how the interviews were recorded over until after the defense requested that document? The defense has not seen anything other than an undated document and the words of McClelland and Mullen that support that the interviews were actually recorded over. This is not normal and is very troubling. Neither McClelland nor Mullen nor anyone else in unified command has ever explained to this court, nor anyone else, why they did not immediately alert the defense that crucial evidence sought by the defense had been purportedly recorded over. Neither McClelland nor Mullen or anyone else has ever explained to this court, nor anyone else, why it took 5 months before providing a document detailing the claim of Mullen of what happened to those interviews. Those are 5 valuable months during which Richard Allen's counsel could have been investigating the actual claim that those interviews were recorded over. This is not normal. 2. For over 4 months, McClelland held on to exculpatory evidence he had in his possession from Todd Click's lawyer, including a certified...
It almost feels like he thinks if he just keeps writing and writing and writing and droning on and on and on and on, that it'll, like the judge will just go, okay, we'll have a hearing, you know. It's just unbelievable. 90% of what this guy says is crap, and he tries to weave in some truths and then hopes that somebody will just believe it.
Letter detailing how a law enforcement officer was concerned, essentially that McClelland may have the wrong man charged based upon evidence that he, Click, and 2 other law enforcement officers had gathered over a lengthy investigation that led them to believe that Holder and Fields and perhaps others were involved in the murders, as this court knows from the Franks memo, including documentation provided to the court in that memo on May 1, 2023. McClelland received through the United States Postal Service a certified mailing from attorney Paul Barada that detailed why his client, Todd Click, was concerned that McClelland did not have all the information necessary before making an arrest. This certified mailing not only contained a letter, but also the actual evidence that Click and law enforcement officers Kevin Murphy and Greg Ferenczi had gathered during their investigation. This included several videos that the prosecution had never turned over to defense from the likes of Elvis Fields, Rod Abrams, Ned Smith, and Johnny Messer. Again, in a normal world, this would be an earth-shattering mailing to receive if you are a prosecutor. Normally, this mailing would cause a normal prosecutor to immediately contact the defense lawyers by phone to alert them that the prosecutor had received this information that clearly was exculpatory. However, that did not happen. Instead, the prosecutor held on to the contents of that certified mailing for over 4 months. The prosecutor only turned those documents over to the defense after it became clear that they, the defense, would soon be learning of that certified mailing. In the August 10, 2023, deposition of Jerry Holman, the defense provided Holman and the prosecution with the 12-page Odin report where the prosecution had to know that Click was a member of that investigation trio of law enforcement along with Kevin Murphy and Greg Ferenczi. Macleod had to have understood that it was only a matter of time before the defense would learn from Click himself that he, Click, through his lawyer, had mailed a letter much like Richie Davis to the prosecutor with exculpatory evidence. Macleod's failure to immediately turn over this exculpatory evidence has never been explained to this court or anyone else. Why did it take Macleod over 4 months to turn over this evidence? Similarly, it took Macleod approximately 4 months to turn over the Richie Davis letters. Delayed discovery of exculpatory evidence without explanation is not normal, but has been a consistent pattern in this case. 3. Why in a September 6, 2023, email to the defense did Macleod claim that the Purdue professor's identity was unknown and perhaps would never be known, when in fact law enforcement had known the identity of the Purdue professor since mid-August 2023, if not before then? And why did the defense only learn of the Purdue professor's identity after the Franks memo was filed, calling out the prosecution for absurdly claiming...
What are you talking about, Deborah? I have no idea what you're saying.
It may not be able to learn his identity, in yet another example of what appears to be an attempt to conceal exculpatory evidence. Macleod has yet to explain to this court.
Oh, what? I mean, you say, was all this disclosed before trial? What stuff? They had hearings on all these people, and there was no nexus found, okay? That's it.
Or anyone else. Why he sent an email to the defense on September 6, 2023, claiming that he and law enforcement did not yet know the identity of the Purdue professor and more. Curiously, that they may never learn of the Purdue professor's identity. The Franks memo was filed on September 18, 2023. Coincidentally, the very next day, lo and behold, Jerry Holman actually found and interviewed the missing Purdue professor Jeffrey Turco. Only 13 days earlier, it was thought that his identity may never be known, according to Macleod, but after the Franks memo, where the missing professor was discussed, he was found almost immediately. Let there be no doubt, the Purdue professor's report, and even his October 19, 2023, interview revealed the murderers may have left behind sticks in the form of runes, consistent with the defense theory.
Right, except, you weren't able to use that at trial because there was no nexus of any of the Odinist people that you think were involved to the crime scene. All right, so this is all just rehashing the same thing over and over and over again. I don't know what you mean, though, Deborah. I have no idea.
This is called exculpatory evidence. Or 4, while Turco admitted in his report from 2017 that he could not confirm what the sticks represented, he also said, the argument that these markings constitute an inscription inspired by Norse runes or modern recreations thereof is quite plausible. These words from Turco were not buried deep in the report, but rather in the very first paragraph. It would not surprising if Holman or Macleod would want the defense to not have access to the report, as that report supported the defense theory that Norse paganists left the sticks behind in the form of runes. In his September 19, 2023 interview with Holman, Turco commented,
it doesn't support anything. It said that he could not confirm that the sticks represented that. And he said, but it's quite plausible. Just meaning, yeah. So it doesn't do anything. It's not proof of anything. And even if you had him come out and say that, who are you accusing of that? Because none of the people like Brad Weber and not Brad Holder, and other people, they weren't, there was no nexus. There was no proof that they were anywhere near the crime scene.
I think the idea that somebody is trying to kind of replicate, early Germanic, runic script, that seems, I think, Given. Both the report and Turco's own words in his interview stray far from what Holman represented in his August 10, 2023, deposition as to what the Purdue professor's words were. Holman claimed under oath that the Purdue professor had stated that the sticks were not Odinism or any type of cult worshipping or any type of a group that would have conducted the crime. Holman, simply put, misrepresented under oath the findings of the Purdue professor, who never said that the sticks were not representative of Odinism.
Yeah,
Rather, the words the Purdue professor used was that the possibility was quite plausible, and it was a given. Holman's
Well, a given means it's basically a fact. Quite plausible doesn't mean that.
Representation under oath is very troubling, and he has never explained himself.
And who cares what the Purdue professor said? Because he's a professor, all of a sudden now we know for certain those are Nordic runes. Give me a break.
To this court or anyone else. The defense believes that evidence supports that Macleod did not want the defense to learn the name of the Purdue professor, and thus the September 6, 2023 email that he, Macleod, has yet to explain. Turco's report and interview supported the defense theory that Odinists, Norse paganists were the murderers that left behind runes at the crime scene. After Holman's September 19, 2023 interview of Turco, Holman prepared a report dated because reports are normally dated September 22, 2023, in which Holman admitted that he had known of the likely identity of the Purdue professor since mid-August 2023. If this is the case, again, why did Macleod not disclose this information to the defense instead of claiming to the defense on September 6, 2023 that the identity was unknown and may never be known? Again, Macleod has never answered that question to this court or anyone else. To the defense, it appears as yet another example of Macleod's attempts to conceal exculpatory evidence from the defense, much like the Ricci Davis letters.
What is a car for kid? I think that's when you can donate your car and the money received from the sale of the car goes to I can't remember which child medical organization that was. I can't remember.
It is not normal. 4. Why did Macleod fail to turn over the faked crime scene photo found on Holder's Facebook page even to this day? And why did Trooper Roland Purdy twice swear under oath that the faked crime scene image was found on Brad Holder's Facebook page before the murders, only to then change his story on August 1, 2024? At the hearing on third-party suspect evidence, as has been noted in the Franks memo and at various other times, the defense found among the massive amount of evidence a report from Trooper Ryan Winters detailing evidence that suspect Brad Holder had an image on his social media pages that depicted two girls mimicking the very crime scene that law enforcement found on February 14, 2017. This image depicted two young girls lying on the forest floor with Styx branches on them, with one of the young girls' arms posed almost identically to that of the Liberty German. This bizarre image had existed on Brad Holder's Facebook page before the murders, according to Trooper Roland Purdy. Why would Brad Holder, an early suspect, have such an eerily similar image on his Facebook page? Unfortunately,
I've seen it. It doesn't look like the crime scene photo. They're fully dressed. They're, they are among branches and so forth, but it doesn't look like the crime scene photos. But you could tell somebody that, and if they're just looking at it like, yeah, that's what they would probably do, but they don't look the same.
Unfortunately, the prosecution failed to produce that exculpatory piece of evidence. The defense had to drive to Georgia to obtain that image from the very man, Ryan Boucher, who had located the image on Brad Holder's social media pages. Trooper Purdy, then under oath at his deposition in the fall of 2023, confirmed that the image was in fact on Brad Holder's Facebook page, but that Purdy did not find the image compelling because it had been on Holder's Facebook page for a few years. On July 30, 2024, Purdy once again confirmed under oath that this eerily similar faked crime image was found on Brad Holder's Facebook page. Then, very curiously, just 2 days later, Trooper Purdy recanted his two previous sworn statements, now claiming that he could not confirm that the image was on Brad Holder's Facebook page.
They don't look similar. There's two girls fully dressed, and they're sort of tucked under branches and so forth. But the reason they look similar to you is because there's branches and they're lying there. They're not nude. There's nothing about that. And people just want it to look similar, so they keep saying they look similar. People want Richard Allen. I'm sure Paula wants Richard Allen to be innocent. And he isn't. He's the killer. He confessed calmly and rationally. And he is Bridge Guy, so he is the killer. Don't worry about that.
Additionally, Trooper Winters claimed in his deposition that Indiana State Police ISP could not locate the faked crime scene image that at one time was in the possession of the ISP post in Lafayette. To this day, the prosecution has failed to turn over said image. This is not normal. It is also not normal for a seasoned state trooper, like Roland Purdy, to retract 2 prior sworn statements during a hearing in which the mimicked crime scene image was a central piece of the defense's argument to allow third-party suspect evidence at trial. 5.
How is an image that you claim is similar any evidence at all that that person committed a crime? There's nothing. They were not able to have any information. Brad Holder has an alibi, for God's sakes. So who cares if he has a picture there?
Video of Brad Holder and Westfall in pagan ritual in Fort Wayne. The defense was fortunate enough to locate among hundreds of thousands of documents a 2-page email from Greg Ferenczi to Tony Liggett dated December 12, 2018, in which Ferenczi describes a strange video that Brad Holder took of a pagan ritual in Fort Wayne, Indiana. 5. In the video, Brad Holder was tape recording various people in a ceremony, periodically yelling out things such as "Hail Thor." At the very end of the video, Brad Holder tape recorded Patrick Westfall standing next to a tree and using his hand to seemingly mark something on the tree. In the email, Ferenczi commented to Liggett about Patrick Westfall marking the tree with his hand. This is significant because of the F found marked on the tree in one of the victims' blood. Law enforcement had believed that the tree was marked possibly by someone practicing Norse paganism or Odinism. The defense did not get a copy of this exculpatory video. Rather, it had to ask the prosecution for that video. Eventually, that video was turned over to the defense. It is not normal for the defense to continually have to request the prosecution to turn over evidence of an...
So this one, it's not normal. That's his one single solitary man in this one. Just repeating the same thing over and over and over.
An exculpatory nature that the prosecution has in its possession. Normally, the prosecution turns over that evidence immediately without any need to request it. This was yet another example of the state of Indiana holding on to exculpatory evidence before being forced to turn it over. Conclusion and request. What has happened throughout this case is not normal. Prosecutors not turning over exculpatory evidence to the defense is not normal. Prosecutors holding on to exculpatory evidence until being forced to provide it to the defense by complaints from the defense is not normal. Prosecutors claiming that they can't locate a key exculpatory witness's identity, a witness, mind you, that purportedly altered the way that the case was investigated, is not normal. Later, learning that the prosecutor had knowledge of the witness's identity in spite of an email sent to the defense claiming that he may never learn of the witness's identity is not normal. The prosecution having no explanation for not providing exculpatory evidence to the defense.
It's not a maybe he was involved, Paula, okay? It's not maybe he was involved. Richard Allen is bridge guy and he was involved, okay? Now, if you want to say that there's some other people there, great. But Richard Allen is the killer. He was found guilty by 12 people. He is actually the killer, okay? I mean, just be a reasonable, rational person. You sound like a lunatic, all right? Yeah, it is kind of a creepy looking sort of picture, but it doesn't look like the crime scene photos. I've seen them, okay?
It's not normal. Having no explanation why a report that attempted to explain why key evidence is forever lost was not dated is not normal. Having a seasoned law enforcement officer recant 2 prior sworn statements concerning a key piece of exculpatory evidence that the ISP claims it cannot locate is not normal. Finally, having a prosecutor claim in an email that he provided all the Ricci Davis letters to the defense before trial, when just 14 days later he was forced to admit that what he, McLellan, represented as truth in his email was in fact not true, is not normal. Nor is it normal that one of the letters can't even be located, and that the prosecution has no explanation for this missing Ricci Davis letter. It does not matter whether the contents of those letters can be questioned as unreliable. That is not for the prosecutor to determine. The prosecutor's only determination is to turn that evidence over to the defense. The defense should have had the opportunity to determine the value of that information contained in the letters. It does not matter whether those letters may conflict with other defense theories, as the defense has a constitutional right to possess all exculpatory evidence, and then to determine how it should proceed strategically in the defense of their client. A local Carroll County rule also requires turning over said evidence. The fact is that
it's a creepy picture, everybody, that Brad Holder had on his Facebook page. Therefore, Richard Allen didn't do it, everybody. Just one single picture out there means that Richard Allen's black Ford Focus was not driving by the Hoosier Harvest Store at 2:27. It doesn't mean that he's the one that passed the 3 girls, even though they all saw him and he saw them. It doesn't mean that he went out onto platform 1, exactly where Betsy Blair saw him and where he said he was standing. It doesn't mean that he's the person. It just goes on and on and on. You guys, listen, if you don't know the case, don't talk about it, okay? And if you know the case, you know for certain that Richard Allen is bridge guy. There is no other option. There's no extra choices that you get to have. There's no outs. There's nothing. Richard Allen even admits to being that person in a confession, and even by saying he's wearing exactly the same clothing and he's the only one there. There isn't another person there that other people saw. Okay, so Richard Allen is the killer, all right? And so there might be other killers with him, and if there are, great, come forward, Richard Allen. Let's hear who those people are. Maybe we can get justice for those girls, but anything that you're going to say that doesn't involve you is completely bogus, all right? But I know the defense team would love that, to find some way to get a killer of 2 girls off.
Prosecution had in its possession letters, in which a key suspect, Keegan Klein, purportedly confessed to the crimes and provided...
I don't know what you're talking about, Jim Long. You make a lot of really strange comments, I don't know what that even means. So I'm going to have to remove that comment. I don't know what the hell you're talking about or anything.
Provided details that only the killer might know, and that information should have been provided to the defense. Because of the prosecution's failure to produce those letters, and because the prosecution has a history and pattern of not turning over exculpatory...
Nobody identified Richard. Look at these look at you guys. You guys are nuts, okay? Yes, Baldwin is butthurt. He tried to convince Kathy Allen and Richard Allen that he could get them off. He knows that they did it, that he did it. And he wasn't allowed to use all the techniques that he wanted to use to try to get him off. And he put on a terrible defense, and now he's trying everything he can to try to make up for it. And it's just not going to happen for him, okay? Nobody identified Richard Allen as bridge guy. You see, look at Lori McKinney right there is one of those people that repeats all the garbage that those other channels talk about, and they're just full of crap, okay? Richard Allen came to the trails at 3:27. That's when, or 2:27. His car drove by. Well, excuse me, it was 1:27. I screwed up on that originally a few minutes ago. It's 1:27. Drove by the Hoosier Harvest Store, and a black Ford Focus drives by, and then just after that, that person, Richard Allen, who was in the black Ford Focus, got out of his car at the Hoosier Harvest Store, and then walked to the trails and passed 3 girls. Those same 3 girls saw him, okay? So right there, that they admit to seeing each other, okay? Now, do you at least agree with that? And if you don't, I don't have time for you, okay? Then he walked to the bridge from there, and it takes 11 minutes. So he would have got to the bridge, so he probably would have passed the girls at like 1:33, and then 11 minutes later, 1:44, gets to the bridge, and he said he went out on the platform 1 to look at some fish. Then just behind him, 3 minutes after he got to the bridge, is when Betsy Blair pulls into the parking area. That means Richard Allen would not have been able to pass Betsy Blair before she walked down. She walked down to the bridge, and guess what? She saw a guy standing on platform 1, and that was Richard Allen, okay? And then she turns around and walks back and passes Abby and Libby, who are heading towards the bridge. That means they have to run into him. Richard Allen said he was wearing blue jeans, a dark blue or black Carhartt jacket with a hoodie and some sort of head covering. Exactly the same clothing. And the 3 girls who saw Richard Allen said he's bridge guy. Okay? So, I mean, Richard Allen admits to being bridge guy because the 3 girls that said that they saw, the person they saw was bridge guy, and Betsy Blair, the person she saw, was bridge guy, and therefore the person in the video walking across the bridge is bridge guy, and that's Richard Allen, okay? It's really kind of clear, and then Richard Allen admits to being on the bridge and taking the girls down the hill, and then he sees a van. It just goes on and 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 on. Richard Allen is bridge guy, And if you can't see it, I'm sorry for your malfunctioning brain, okay? Okay. See, whatever time you hear that, it goes off the rails, all right? So, have a good one. How many people in Indiana wear those kind of clothing, you guys? How many people wear that type of clothing? Oh boy, you guys, how many people wear this clothing? Let's see, how many people on a Monday afternoon at 1:30 wear exactly that clothing that Richard Allen said he was wearing on the trail when he's the only guy that anybody saw on the trail? Just get a clue, okay? God, it's just so frustrating listening to these people.
Evidence. Richard Allen deserves another trial. Richard Allen, through his counsel, therefore seeks a hearing in which the prosecutor is requested to explain why he failed to turn over the Ricci Davis letters, why he misrepresented his possession of those letters to defense counsel in his February 13, 2025 email, as well as to explain the other examples of failing to turn over exculpatory evidence as recited herein, which show a pattern of such conduct. The defense seeks such a hearing in order to, 1, use the state of Indiana's answers to these questions in a renewed motion for new trial based upon newly discovered evidence,
Lori,
and also 2...
Listen, Lori, you are clueless, okay? I'm just telling you. I know this case very well. I know all the little details. Richard Allen is bridge guy, and there's no out for him. The fact that you can't see it does mean that you're clueless, okay? Now, you might have a functioning brain, but you just kind of go with the whims and what other people are telling you because you are 100% wrong. And in fact, the jury also could see it too. And that's why he was found guilty, okay? Richard Allen is the killer. I know you love the guy. He's a great guy in your mind. You'd probably let him take care of your kids. But he's a killer, okay?
In order to use the state of Indiana's answers to those questions as a record that can be utilized by the appellate lawyers, should this court deny Allen his request for a new trial? Lastly, Allen asks this court to order sanctions against the state of Indiana for violating the Carroll County local rule concerning exculpatory evidence. The sanction the defense is seeking is ordering a new trial. I swear and affirm that the statements contained in this memorandum are true and accurate to the best of my knowledge. Andrew J.
That's not happening. It's not happening. Yeah, look at these lunatics. Like, now here comes Karen Jones, probably a buddy of Lori. They came in together from an outside, coming in here. CJ, Lori's correct. Not one witness pointed to Richard Allen as bridge guy. Yeah, you know what? You know why? They didn't point to him in court and say, that's the guy I saw. You know why? Because Richard Allen had a mask on right here. But guess what? He admits to being the person that the 3 girls saw. Do you agree with that, Karen? That the 3 girls, when they saw him, that they admit to seeing each other, right? Richard Allen saw them and they saw him. Do you admit that? Okay? Do you admit that? See, that just shows you how your brain doesn't function correctly, Karen. You don't get the logic here. Do you admit that when Richard Allen got to the trails at probably about 1:33, that he passed the 3 girls and they saw him and he saw them? What do you mean, where was that testimony? Are you that clueless? What do you mean, where was that testimony? It was in the probable cause. It was in the trial. The whole thing. Listen to this person, you guys. Where was that testimony? All right, I got to get rid of you. Sorry. Don't have time for people like you. All right? You're not providing compelling or interesting information. You're just looking for a reaction. All right? So have a good one. Take care. Have a good time somewhere else. Yeah, I'm not going to explain it to you. It's at the trial. He passed the black Ford Focus, drove by the Hoosier Harvest store at 1:27. Parks its car, probably 1:28, 29, got out. 4-minute walk. 1:33, passes the girls. 11-minute walk from there to the bridge, it's 1:44. I've already explained it 100,000 times on this channel. And if you don't understand it, then I'm sorry. Okay? God, it's just so frustrating, you know. Where was that testimony? There's no testimony where somebody points at him and says, that's the guy that I saw. Right. However, The 3 girls, when they saw... What do you mean he left at 1:30? What are you talking about? He didn't leave at 1:30. He got there at 1:30. His second story was told that he got there at 12 and he left at 1:30, which is not true because those same 4 girls, they got there at 12:15. They walked the entire trail, hung out at the bridge, then walked back and hadn't seen him until they were leaving. And he even admitted that he got there at 1:30 and he left at 3:30. Then he changed his story for the idiots out there to believe that he got there at 12 and left at 1:30, completely changing the time frame when he was interviewed later. But back when Dan Doolin interviewed him, it was 1:30 to 3:30. Okay? Where are all these people coming from? Hey, Bill Mayhem, are you one of those people who got one of those freebies? Let's see. The video on Libby's phone points square at him, and his statements made is obvious. Yeah, well, it looks just like him. Yeah. Richard Allen said he got there at 1:30 and he left at 3:30. And we know that's true because when he got there, that's the same time that the 3 girls saw him and he saw them, right? And those girls said the person they saw was the person in Libby's video. Okay? So at that point, they've already identified the same person in Libby's video is Richard Allen. So then Richard Allen goes to the bridge and he's standing on platform 1. And then Betsy Blair, who was not 50 feet but 110 feet away, was looking at him and described him a little differently, but also said that the person she saw was a person in Libby's video. And he was standing on platform 1. And that's exactly the same platform that Richard Allen said he was standing on. And so the person, and then when Betsy, and the timing is so perfect that it has to be Richard Allen, because he would have got to the bridge at 1:44, and it takes 6 minutes to walk from there to the parking spot by across from the mirrors. So he would have got there at 1:50, but Betsy Blair already got there at 1:47. Or 1:46 even. And so got out of her car and then walked out, and so she would have been on the trail when he was about halfway there. But he wasn't. And she walks down, and there he is standing on platform 1. So if there was 2 guys that looked just like him, where did the other guy go? Yeah, see, you guys, it's just, it's mind-boggling. Mind-boggling. So it's just amazing the information that these people don't know. Okay? People like Lori and people like Karen Jones, etc., they don't know specific facts, and they come in here just spewing the same crap that they heard over on Burkhart's channel or Bob Mata or any one of the other billion, just wacko YouTubers who cover the case and think that Richard Allen is innocent. And it's insane. That's based on nothing. If you, the facts in the case absolutely point to Richard Allen being the killer and nobody else. And he did it. And he confessed 60 times. And his original confessions were before he was deemed crazy. And he spoke rationally and calmly. And he said he did it. And even when they tried to get him off, he goes, I just want to let you know that I did it. Okay, and then when he realized they weren't accepting it, he goes, well, I think I did it, because he sort of wanted to, come off of it. But there was other times where he didn't even do that. He just kept going and saying, no, I did it. I just want to make sure that you'd still love me even if you knew that I did it. And he said it over and over and over again, calmly. And his voice, apparently, every single person that heard his voice in those interviews said it sounds exactly like the person in Libby's video. All right, so you can believe whatever the hell you want to believe, but the facts of the case all point to Richard Allen, and all this little smoke and mirror crap stuff being done by Baldwin is just that, smoke and mirrors. But anyways, I'm going to get going, you guys. I get way too frustrated with these people. They're just absolutely clueless. So anyways, thanks K-Me, and also for 26 months. And then we had Jerry Walker, GSU PM with the cat eye. Thank God for that, or we just would have had another disastrous evening. And then we had Camden Edwards, K-Me, and Jim Lawn. All right. Well, thanks, everybody. You know what I'm going to do? I'm going to spin for all the different names. I don't know if I got every single person. This is from yesterday and today. Yeah, there really isn't really even that many names for 2 days. Let's see. Okay, here we go. This is for the notebook again. All right, here we go. Who's gonna win? Who's gonna win? Karen. All right. I don't see her in here, but there she is. All right, there you go, everybody. Thanks for being here. We'll see you guys later. And as I always say, until next time, be safe out there. God, just crazy people.
Yeah, I've been doing this true crime thing for quite a while now.
Don't know what that means. 1:30
and during
to
this whole
3:30.
time,
Yeah, it's 1:30
I have
to
not
3:30.
seen one person
That's what I said.
that is a crime dissector, plug rejector. I'm a certified human lie detector. Gonna get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Grader's gonna give another lecture. Crime collector, freak connector, and I'm always gonna be a pup protector. Fool deflector, interceptor, and I'm meaner than a specter with a vector on his pector. With all respect, y'all, just remember I've a temper fucking check ya. I have no agenda, I'm no pretender, and I'll serve it to you.
Thanks, Alex Lambert, for the PayPal.
And in the end, I'm gonna send ya on a mission to reveal the true offender. Yeah, so I'll just get right back to work.
Thanks, Alex Lambert, for the PayPal. All right, everybody. Hopefully tomorrow's a better day.